Hi, everybody. My name is Dave Stouse. I'm a partner here at Husch Blackwell. I'd like to welcome you to attend our webinar here today, analyzing the California Privacy Rights Act final regulations. We have a lot to get through today, but I just wanted to kind of give you a few prefatory instructions. First, I know a lot of you will attend for CLE purposes. My understanding there's a link at the bottom that you can get access to your CLE records. If not, you can feel free to email us at the firm and we'll help you get that across the finish line. There's also access to a copy of the slide deck back there. I know a lot of you like to print those out and keep them for your records, so you should have availability to those. If you have questions, feel free to ask. We typically get a lot of questions, and a webinar like this where it's highly attended, the questions tend to come in more than we can handle. So we'll do our best to answer questions along the way. Maybe as we talk, we'll answer some of those just based on the topics. But if not, maybe we can type an answer to your question or address it afterwards. These are your illustrious panelists today, Shelby, TK, and myself. That's what I used to look like before COVID, and now I've got a beard. Right? It's always interesting looking at that picture. What I'll say is we got the QR codes at the bottom there. Those are QR codes to our LinkedIn profiles. If this topic is of interest to you, I encourage you to follow us on LinkedIn, where we push out content. And also, we've got slides for the blog posts that we push out as well. I know a lot of you track it anyway, so I won't belabor the point. Moving on, then, I think people, if you've attended one of our prior webinars, you know that we like to start with a roadmap, right? You can see where we're going, understand how we're going to get there, and maybe this helps avert some of your questions along the way. Listen, I'm just be blunt, right? And actually, one of our clients just emailed me when he saw the slide deck when we came on here saying, how are you going to get through all those slides, right? I don't know. There's a lot, and there's a lot to unpack here. Shelby and TK said, well, Dave, just talk less, right? And we'll get through the slides. So I suppose, we could take that approach. But what I'll say is we're going to try to jam a lot in here. I'll also say there's a number of slides here that we use screenshots from the final statement of reasons, the comments to the final statement of reasons in the appendices. We might not go over all of those, but I know a lot of you like to take the slides and use them for your own purposes, print them out. So we want you to have as much context and as much thought process as possible in how we've come up with our slides. And to tease that out just a touch, it's going to be, what got presented to the Office of Administrative Law. The package involves the rules, it involves the final statement of reasons, it involves, the back matter that they've used to come up with that information, and also includes two different appendices of comments to the rules. The 45-day comments, which is like 367 pages long, and then the 15-day comments, which is shorter. I think it's like 160 something pages. Don't quote me on those numbers, right? But point being is, like, you can go through those documents and come up with a lot more background and information for how the agency came up with its rulemaking decisions. And that becomes really useful when we get into these nuanced issues. Okay, so let me start with the takeaways, which are takeaways. No real segue into that one. Yeah, 5 topics right off the bat. Lots of changes to operationalize. We're going to go through a lot of those. When I say lots of changes to operationalize, we're taking the perspective of, like, say you're CCPA compliant. Now the amendments have gone into effect, and now you're doing the rulemaking amendments as well. So we're talking things about, like, updating privacy policies, sell and share. Now we've got share. We already had sell. Opt-out preference signals are things that we've been talking to clients a lot about. Operationalizing rights, like the right to correct, to limit the use of sensitive personal information. 2 things I think are sneaky, though, that we're going to talk a lot about, in particular Shelby and then TK later, is user experience issues. And this is what TK will talk about a lot with hers. Like, this idea that it's not just enough to have a website with privacy policies and those types of things, but like the user experience on your website of how they are presented with choices and how your information is presented to them is becoming very significant to the agency. And so it's not just enough, again, to have, like, content on paper. Now it's also about how we're presenting that content to people, and TK will dive into that. And the thing Shelby's going to dig into off the bat is Rule 7002. I think this one's just really significant, and Shelby will get into it. I'll just tease it a little bit, but this is the concept of, like, what's in your privacy policy is not going to necessarily dictate what you do with your privacy practices, right? It's going to be the context in which the consumer comes to you, proportionality, compatibility. these concepts, this upfront basis for collecting information that is really fresh and new with these regulations. And then I'll skip a couple there. I mean, you can read the slides, right? But the changes from the initial draft mostly reduce requirements. So what I'm getting at there is you'll see a lot of places where we say shall became may. But to understand the context overall from the CCPA regs to the new regs, so like what we had in 2020 to today, many, many more requirements. What I'm talking about this mostly reducing requirements is from the first draft regulations that came out. And now we're seeing, inevitably, we see a walk down of certain things, the shalls to the may. And then, the cross-state issues need careful consideration. If we call them a five-stater, right? If you're subject to all five-state privacy laws, blending, Colorado rules with the California rules, just a lot to be thought through there. Okay, current status, and then I will turn it over to Shelby. So the timeline, Valentine's Day, you may have been thinking about love. We were thinking about privacy because the Office of Administrative Law decided that was the day that they would file the final package with, the agency, the California Privacy Protection Agency decided they would file the rulemaking package with the Office of Administrative Law. So by law, there are 30 business days for the Office of Administrative Law to review those. I did the calculations. I came up with March 29th because I skipped President's Day, which I understand. But I'd probably say given math's not my strong suit, maybe we would say plus or minus March 29th, right? To give me some hedging there. It also doesn't mean it's going to take that long. The Office of Administrative Law can do it quicker, right? But that's basic, what you're looking at right now. July 1st, 2023, it's the start for the enforcement. But understand CCPA is still in effect, right? And the B2B exemption expired, the employee exemption expired. So, your work should be progressing along those issues. Rulemaking, and this, I'm sorry, don't shoot the messenger portion of the program today. We finished one rulemaking package and we're going to enter into the next rulemaking package. So the topics for this are going to be cybersecurity audits, risk assessments, automated decision-making. Personally, I think the automated decision-making one is going to be really groundbreaking here. We see some of that in Colorado, but I think that's going to be potentially transformative. So the status of that is we've got preliminary comments, the request for preliminary comments, and they're going to engage in a rulemaking process there. So more to come for sure. I do want to say, we're talking California, but I do want to say Colorado real quick. Hearing is done. The public hearing is done in Colorado. Adopted regulations were filed with the Secretary of State on February 23rd. They are still subject to Attorney General review. I know it sounds a little bit odd that the Attorney General is going to review what the Attorney General's office just did, but that's the way it works. There is a red line. So we have now another version that was filed with the Secretary of State. There were changes in that version filed with the Secretary of State, but still potential for more changes to come. There is a red line that we produced at Husch. It's on LinkedIn, and I think we're going to push an article out tonight with it as well that shows the changes between version 3 and this final version. If you need it, let us know or friend or follow on LinkedIn. But point being, Colorado is getting very close to being done as well. Okay, so with that, let me turn it over to Shelby to take you through 7002.
Thanks, Dave. Like he mentioned, we're going to start diving into these final regulations by first looking at the restrictions on the use and collection of personal information. This section underwent significant revisions from the first draft of the regulations, like Dave touched on, and it was the subject of extensive debate at board hearings. So to start with the standard, it requires businesses' collection, use, retention, and sharing of PI to be reasonably necessary and proportionate to either achieve the purpose for which the PI was originally collected or processed, or another disclosed purpose that is compatible with the original reason the PI was collected. So first, we need to analyze whether it is for the purpose for which the PI was originally collected. The purpose needs to be consistent with the reasonable expectations of a consumer. Now, this is a bigger change. The final regulations revised this language from an average consumer to reasonable expectations of a consumer. And so with looking at what is a consumer's reasonable expectation, we look at this 5-part analysis. The regulations originally included factors, but this language was removed to try to eliminate the suggestion that the clauses were to be balanced against each other. Now businesses are to conduct a 5-part analysis, and the regulations actually contain a number of examples that we recommend reviewing with each part of this analysis. Like Dave mentioned, we're going to point out a few comments in response to the final statement of reasons. This one's important to note because the agency actually pushed back on a comment that said, hey, a notice such as a privacy policy actually determines how organizations can use data because that shapes a consumer's expectations, not the factors or the 5-part analysis. And the agency disagreed in their response here. So now let's move to the compatibility analysis. When is another purpose going to be compatible with the original purpose? The regulations provide that businesses need to consider, again, the expectations of the consumer at the time of collection, which brings us back to that 5-part analysis. But you also have to consider the strength of the link between the original purpose and the other disclosed purpose. For example, the regulations provide that a strong link would exist when a consumer's PI is used for the requested service, and then would also be used to repair an error with the functionality of the requested service. Whereas a weak link is going to exist where a consumer's personal information is collected for cloud storage, but then is going to be used for a different service such as facial recognition. That's going to be a much weaker link there. The agency emphasized in its response to a comment that just because a use is disclosed to the consumer does not by itself satisfy this reasonable expectation analysis. So this discussion is focused on disclosures in a privacy policy again. Businesses have to go through the 5-part analysis to make the determination, and they cannot just rely on disclosures in a privacy policy. Lastly, businesses need to always consider whether the collection, use, retention, sharing is reasonably necessary and proportionate. The regulations require businesses to consider the minimum PI that's necessary to achieve the purpose, any negative impacts, and the existence of safeguards that will address some of those negative impacts. So like Dave mentioned, a lot to unpack with this one, but I am going to pass it over to TK to discuss consent next.
Thanks, Shelby. So we'll now touch on the requirements for methods of submitting CCPA requests and obtaining consent. So when designing and implementing these methods, businesses must incorporate 5 principles. The methods need to be easy to understand. There needs to be symmetry and choice, which I'll elaborate on in a second. Avoid confusing language and interactive elements like double negatives. Avoid choice architecture. And last but not least, the methods should be easy to execute. So for symmetry and choice, essentially consumer choices, they must be symmetrical. The path of a more privacy protective option needs to be equal or symmetrical to that of the other option. For instance, using an accept all and decline all button or buttons rather than accept all and more information, because requiring a consumer to take that additional step to decline is not symmetrical to the one-click accept all button. Also worth noting, the example in the draft regs that said having a more prominent yes button than a no button is not symmetrical, that did not make it into the final regulations, just FYI. And so as for the 4th principle, choice architecture, or avoiding choice architecture, this means avoiding designs that would impair or interfere with the consumer's ability to make a choice, such as bundling incompatible uses with uses that are reasonably necessary and proportionate, or requiring consumers to click through disruptive screens before they can submit an opt-out request. So ultimately, a method that fails to comply with the 5 principles may be considered a dark pattern. The regs now also state that intent is not determinative, but a factor to be considered when, when determining whether a method or user interface is a dark pattern. So for example, deliberate ignorance of how your user interface affects consumers might weigh in favor of establishing a dark pattern. And the FTC actually issued a report last fall on dark patterns, which we link here in case you're interested in learning more. Now back to Shelby to discuss privacy policies.
So, privacy policies. Section 7011 focuses on the requirements for what you have to do with privacy policy, content and posting. So in general, the final regulations do not make too many changes to other drafts, but we'll just highlight some of these posting requirements that are new. You have to post through a conspicuous link using the word privacy, which we're all getting pretty used to. For websites specifically, the link needs to appear in a similar manner as other links on the homepage. So think same font size and color. For mobile apps, the link to the privacy policy may be included in the settings menu. This actually changed from must include to may include with the final regs. So this is now just an option. But it's still, with your mobile app, must be accessible through the platform page or the download page of the mobile application. So, new requirements for privacy disclosures. Just a few to note. You need to include disclosures on sharing information, whether a business uses or discloses sensitive PI, the new consumer rights, which we're going to cover a little later on, and if applicable, the content of the notices for the right to opt out of selling and sharing, and the right to limit the use of sensitive personal information. One note that we did pick up on in a response is that all businesses need to provide a description of consumer rights, even if they don't have to comply with these requests. This response is really targeting entities that have GLBA data, HIPAA data, these types of entities. Even though the exceptions are going to apply to their data, the entities still need to list the consumer rights in their privacy policies. Dave is going to cover opt-out preference signals later on, but for purposes of the privacy policy, just wanted to note that the regulations do require that businesses include a disclosure. Businesses must explain how an opt-out preference signal will be processed, how it applies, and how a consumer can use the signal, including if a business processes opt-out preference signals in a frictionless manner. Another note we wanted to point out is that the regulations make it clear, and this response reinforces this position, that the disclosure needs to cover opt-out preference signals, not just the global privacy control signal, which we're hearing a lot about. The response explains that they don't want to limit this to one type of signal, so the disclosure needs to cover all opt-out preference signals. So I'm going to pass it back over to TK to discuss notices.
Yeah, all right, notices. The CPRA requires 4 types of notices. In the interest of time, we're only going to walk through the first 3 here because the regs didn't make any significant changes to that 4th financial incentive notice one. So first, we have the notice at collection under section 7012. If you control the collection of personal information, the CPRA requires you provide consumers with a notice at or before collection. How and where you provide the notice kind of depends on the type of collection. So for example, if you're collecting online, you should post a conspicuous link to the notice on your website's introductory page and any other pages that collect PI. These are what the notice at collection currently requires. Data retention is new. If you're collecting information online, the notice may be provided with a link that takes the consumer directly to the specific section of your privacy policy that contains these disclosures. But note, The regs were revised to clarify that a link directing consumers to, say, the beginning or some irrelevant section of your privacy policy, so the consumer is required to scroll through other information to find these disclosures, that does not satisfy this standard. It has to be directly to like your specific California, these disclosures. Where third parties control collection, for example, if a first party allows another business, which is acting as a third party, to control the collection of information from consumers, say, browsing the first party's website, both parties are obligated to provide a notice at collection. However, the parties may provide a combined notice. Also, we wanted to point out that the final regs no longer require the first party to name all such third parties in its notice at collection. That used to be a requirement, but no longer. So the regs provide this example that kind of teases out the previous slide, that both parties are required to provide the notice, but the third party may do so by including its own information practices in the first party's notice at collection. I also want to point out here that this example changed substantially from the initial draft regs, with them replacing analytics business with third-party ad network. Here's another example from the regs we thought would be helpful because it shows that a retail business can post its in-store notice at collection at the entrance or at the point of sale. Dave will now walk us through the other two notices I mentioned.
Thanks, TK. Moving on, I'm going to go through first the notice of right to opt out of sale / sharing and the opt-out link. Everyone's familiar with all the links we are doing these days on website footers. So let's start with the link first. The big thing you're probably, and maybe you're across the finish line on this anyway. I know we are with a lot of our clients. Do not sell has become do not sell or share. If you sell or share personal information, and just for a refresher, shouldn't assume that y'all know what share means, because it's just comes out of kind of nowhere. Cross-contextual behavioral advertising, right? So sell remains sell, which is the transfer of personal information for monetary or other valuable consideration. Share becomes basically target advertising, roughly equated in the other privacy laws. Cross-contextual behavioral advertising. The location, we've used this word homepage a number of times in the slides. Thought maybe it's worth teasing it out for you a touch. So the statute defines homepage, right? And so what it tells you is that's your introductory page of an internet website, as well as any internet page where the personal information is collected, right? So that dictates, how you're going to use these links, right? Website footers being the obvious choice, I think, for doing your notice of collection and your do not sell or share, and that's pretty prevalent. But this concept of homepage is not just a landing page; it's anywhere where you're collecting personal information, and that becomes a consideration when you think about how you're using cookies and tracking technologies on your web pages, web forms, all those types of things, right? Okay. So conceptually, what the link must do, it's got to either immediately opt the consumer out of the selling or sharing, or it's got to take to a web page where they can learn more about their right and effectuate the opt-out. We do have these exceptions, right? So one is the alternative opt-out link. TK is going to talk about that in a little bit. The other one would be to process the opt-out preference signal in a frictionless manner. I'm going to talk a lot about opt-out preference signals, but that's, probably you're familiar with like GPC, Global Privacy Control Signal. So conceptually, if you're recognizing GPC signals and any other opt-out preference signals that the AG's office tells us that we need to recognize, then you could get rid of the link if it's only online collection of sales, right? If it's offline, and I'll go through that in a little bit in a second. I thought this was, when we were coming through the comments, this was a question I feel like was coming up a fair amount with clients, right? Which is like, what if I sell but don't share? What if I share but don't sell? What does the link need to say? And the comments kind of put a pin in this one, right? You can see on the left side on 235 there, they want you to amend they were asking the agency to amend the regulation to allow the post to alternatively say, don't share my information or don't sell my information instead of don't sell or share. And the agency said, go pound sand, right? They said no change is going to be made. We can't change the statutory language. So, just more useful information there. Okay, so the notice, so let's talk about links, and now we're talking about what the notice would say. Again, you only need to provide this if you are selling or sharing personal information. We talked about the location. That is, and this is where the notice would appear, right? So that's after you click on that link. This is where it would drop you onto that page, and the notice of the information would appear. Or it could take you to a specific section of the privacy policy, very conceptually similar to what TK was talking about, the notice of collection. You could click on the notice of collection link, and that would deep link you to the section of your privacy policy that has that information. Or here with the notice of right to opt out, that could similarly be the same, or it could take you to the privacy policy. And then there's for offline, I think that stuff makes sense, right? Offline collection, paper form, signage, those types of things. And again, this exception would be to this notice requirement would be if it immediately opts the consumer out, or you process opt-out preference signals in a frictionless manner, then you're just providing the notice in your privacy policy. The notice contents then, what does the notice need to say? Describe the right to opt out of selling or sharing, and then provide instructions for submitting the request. If it's online, then you have to have that interactive form for submitting requests. So these interactive forms are becoming, required. There's lots of talk on that in receiving requests, and there's also in the opt-out as well. Okay, so with that, I will turn it back over to Shelby to take us through SPI.
Yep, okay. Notice of the right to limit use of sensitive personal information. So to start, how do we know if we need to provide a notice? Businesses do not have to provide the notice of the right to limit the use of sensitive PI if the business only uses and discloses sensitive PI for the designated purposes, or the business does not collect or process sensitive PI to infer characteristics about a consumer. So the agency made it clear in one of their responses that the requirements under this section do not apply if a business does not collect or process sensitive PI to infer characteristics about a consumer. So this is going to be our threshold question there. The CPRA defines infer to mean to derive information, data, assumptions, or conclusions from facts, evidence, or another source of information or data. So if a business is not using sensitive PI for this purpose, no notice is going to be needed. So, like I mentioned, there are purposes. We have eight designated purposes for which a business can use sensitive PI and does not have to provide notice as well. It was originally 7 in the draft regulations, and they added on an 8th. All purposes must be reasonably necessary and proportionate. The draft regulations had this requirement in some of the purposes originally, and not all of them. And so now you have to consider whether every single purpose is reasonably necessary and proportionate. So I'm not going to walk through all 8 purposes in the interest of time, but wanted you to have them here. The regulations also provide further examples explaining these purposes as well. So we recommend taking a look at that too. So I'm going to hop on over here to opt-out links. So similar to our notice to opt out of sharing or selling, but here we're talking about limiting the use of sensitive PI. So similar to the setup with selling and sharing, businesses need to provide that link in their homepage, like Dave was talking about. And for limiting the use of sensitive PI, when a consumer clicks on that link, the link needs to either immediately opt out the consumer, or it needs to take the consumer to a web page where they can make an informed decision. And TK is going to cover this, but businesses also can use an alternative opt-out link instead of just posting the one limit my use of sensitive PI link. Okay, so if a business is required to provide that notice. This notice can be provided on the actual web page where a consumer is directed when they click on that opt-out link, or it can direct the consumer to a specific section within the privacy policy. Again, it needs to take the user into that section of the privacy policy, not just a broad privacy policy link. And if clicking the link immediately opts out consumers, if you go down that route, the notice can also, again, be provided in the privacy policy. Okay, so what does the notice need to say? The notice must describe the consumer's right to limit. You need to provide instructions for how to submit a request. And if the notice is provided online, the notice must include an interactive form where the consumer can submit their request. I'm going to touch on complying with these types of specific requests later on, but for now, TK is going to discuss alternative opt-out links.
Yeah, so as Shelby was saying, this is kind of an exception to the other two links. The alternative opt-out link allows you to provide a single link for consumers to exercise both their right to opt out of sales and sharing and the right to limit the use of sensitive personal information, instead of, having two separate ones and getting that footer all cluttered. It needs to be titled Your Privacy Choices or Your California Privacy Choices, and it must include the specific opt-out icon adjacent to the title that we have here in that third box down. When clicked, it must direct consumers to a web page with a description of the two rights and the mechanism by which consumers can exercise those rights. And I guess on a lighter note, for those of you also subject to the Colorado Privacy Act, the Colorado final rules added a Your Privacy Choices link title option as well. So you can have one link to satisfy both states. Now switching it up to consumer requests. Sections 720 to 24 cover requests to delete, correct, and no. The regs revise these sections to apply the existing methods for submitting requests to delete and no to the right to correct. So the CPRA consolidated requirements for the types of methods for receiving requests to be the same, whether it be deletion, correction, or a right to know. So a business that operates exclusively online and has a direct relationship with the consumer is only required to provide an email address. But for all other businesses, they have to provide two or more methods, one of which must be a toll-free number. And if you maintain a website, another method has to be through the site, such as a web form. The regs similarly updated the timelines for responding to requests by expanding requirements to the right to correct. So for any request to delete, correct, or no, you have 10 days to confirm receipt and 45 days to respond. The regs also expand on what businesses, service providers, contractors, and third parties need to do for requests to delete. So businesses, they have to notify their service providers and contractors, who in turn must delete the PI and notify their own service providers. Notably, the biggest change here is their addition that clarifies that a service provider or contractor may utilize self-service methods that enable the business to go in and process the deletion request itself, which is that second box on the right there. Businesses also should notify any third parties to also delete unless it's impossible or involves disproportionate effort, which is designed in the regs, or defined in the regs. So section 7023 tells us how to work through requests to correct. To determine accuracy, you have to consider the totality of the circumstances, such as the nature of the PI, how it was obtained, and any documentation relating to its accuracy. When processing the request, you also have to instruct the same of your service providers and contractors. And to help alleviate the cost of compliance, the regs now also allow you to delay compliance where the PI is stored in an archived or backup system until that PI is restored to an active system or otherwise accessed or used. You're also allowed to delete the PI instead of correcting it if it doesn't negatively impact the consumer or the consumer consents to deletion. So the section also provides how to confirm compliance. So you'll need to inform the consumer of your decision. If it's denied, you'll have to explain why. If you got the contested PI from a different source, you have the option to provide the consumer with the source's name, which that used to be mandatory, but now it's discretionary. And upon request, you should disclose information that allows the consumer to confirm that you corrected it. Now to Dave for opt-out requests.
Thanks, TK. So again, pivoting to the right to opt out of selling and sharing, section 7026. So again, we're talking about methods for receiving, right? How do you receive these requests? You use two methods here. One of them has to reflect the primary way in which you're doing business with consumers. If you're online, that top box there, you need the interactive web form link. And again, this recognizing opt-out preference signals, and I'll talk about those in a touch. But it's mandatory to recognize the opt-out preference signal. So you're always going to have to be doing that. The third bullet point or privacy policy if the business processes opt-out preference signal in a frictionless manner. So again, that would be placing that notice in your privacy policy if you are in fact not required to have that link because you are processing opt-out preference signals in a frictionless manner. You're probably wondering what frictionless means. We'll go into it in a little bit, but just sort of teasing this out right now. There's just the last bullet point is it seems to come up a lot in conversations. They have this reference to cookie management tools, right? And what it tells you is a notification or tool regarding cookies, such as a cookie banner or cookie controls, is not by itself an acceptable method for submitting requests to opt out of sale and share, because cookies concern the collection of PI and not the sell and share of PI. And then it goes on, second sentence there, you can read it. And so, I think it's caused a lot of confusion, frankly, at least from where I sit. And, so we went through and we're obviously pretty anxious to see the final statement of reasons, the responses to the comments. And there was one in particular, 477 here, that really, dug into it, right? Saying, hey, how should we be using cookie management tools? Does that work? And what is the setup here? And, asking for basically for clarification on this issue. And the agency said, we're not going to change it. They said the regulation's reasonably clear. And then they, to tease out the rest, is stated in 7026A, an acceptable method must address the sale and share. But I think the highlight section is kind of really useful here. If a business seeks to update its user interface to specifically address the right to opt out of selling and sharing, the opt-out mechanism in that interface must address the sale and share of PI and comply with the requirements of 7026 and CCPA for opt-outs. And they say, as stated in the regulation, a cookie banner or cookie control that addresses the collection of PI and not the sell and sharing is insufficient under 7026. So, for those of you who have pivoted to cookie banners, I think they should, right? I think, or at least cookie preference centers, I should say, is probably a better way of saying it. I think what they're really getting after is how is that set up, right? What does that look like? How does it look to the consumer Does it reference seller share? Are you just using your GDPR banner with the 4 sliders and the categories and all that type of stuff? Or are you being delivered about what it looks like for California purposes? At least that's where the mind goes, I think, when you read this response to the comments. But I do think that this is very helpful, and it's obviously why we've included it here. Okay, processing a request to opt out. I think this is stuff we've dealt with before. You have 15 days to, except we've added the share, right? We have 15 days to process it. And then in that between time, so say like you get the request and say it takes you 15 days, and say in the middle there that you've sold or shared information in the middle of that 15 days, and that's the point in time in which you need to be notifying third parties and directing them to comply with the request. And then forward it off to any other third parties that window, that 15-day window. And then confirming the process of the request before I turn it back over to Shelby. This is, again, you may recall in the very beginning that I was talking about, like, we've seen shalls turn to mays, right? And this is one of those instances here where the business may provide the means by which a consumer can confirm that their request has been processed before it said shall in there. And they have an example here, which I think is helpful and illustrative. For example, the business may display on its website the consumer opted out of the sale/sharing, or display through a toggle or radio button that the consumer has opted out of the sale or share of their personal information. So again, all of these sort of, signals to people, opt-out preference signals, limited use, all those types of things are becoming mays and not becoming shalls. Not to say that the agency won't come back on stuff, right? I think I haven't said it yet, so it's probably worth saying out loud, is there is a lot of talk in the board meetings, the agency board meetings, so that's with like Taggart and Lydia Del Torre, all those, people on the board, about, well, fine, let's get these regs done, because we know that businesses are so concerned about having time to comply. And we're sitting here, it's March, right? And July is really the enforcement stuff. And so there's a lot of talk in those board meetings about, like, let's get it done. And if we need to double back and do stuff, we have the ability to double back and do stuff, right? And I think if you're sitting out there, what that means is, this is not, hey, we're done, it's over with, and this is the last you're going to hear on these regulations. I do think that there is an undercurrent here that the board has a willingness and the desire to come back, especially on what Shelby talked about, 7002, that proportionality and compatibility stuff. That is absolutely something, and Shelby mentioned in her comments about, people are going to want to come back and revisit those issues. And I think McTaggart said it in one of the board meetings. Alistair McTaggart, who's now on the board, replaced another board member, said, we have the ability. I think he said in one of the meetings, he said, I wouldn't be surprised if we were talking about rulemaking at every single board meeting, right? So again, a lot of these comments that you see, not to belabor the point, but a lot of these comments that you see in the final statement of reasons say things like, well, maybe that's for later. Maybe that's something we can double back on, right? So this is going to be a moving target process that I think you're just going to be, sadly, you might be upset. You'll be talking to me for a while. You'll be seeing us for a while on these issues as the ball keeps on moving. Okay, so with that, let me turn it back over to Shelby to talk to you guys about the limit the use of sensitive personal information.
Okay, Dave, on that happy note, I will cover the last types of requests. How to comply with a request to limit the use of sensitive PI under Section 7027. So this is going to be familiar here. Businesses must provide 2 methods for consumers to submit requests. One method, again, must reflect the primary way the business interacts with consumers. Like TK and Dave have been touching on, this is going to be consistent with how to handle other requests. So for these specific types of requests, required methods do not include recognizing opt-out preference signals, because this functionality actually doesn't currently exist for limiting the use of sensitive PI. Also, a notification or a tool for cookies, we're seeing those cookie pop-ups, also by itself are not going to be an acceptable method for submitting requests to limit the use of sensitive PI, because cookies concern the collection of PI and not necessarily the use and disclosure of PI, which is what we're concerned with limiting the use of sensitive personal information. Lastly, unlike with some of the other requests, this type of request doesn't have to be verified. Okay, so how do we process a request? Businesses must stop using or disclosing sensitive PI within 15 business days and must notify and instruct service providers and contractors to comply with the request. This is different than the opt-out of sale and sharing request because you don't sell or share PI with service providers, but you can send sensitive personal information. So service providers also need to comply here. For disclosures to third parties that are made during the time you receive a request and that time you process requests, so within that 15 days, the business also has to notify the third party to comply with the request. So it's important to remember that you have obligations not just for you as a business, but with your service providers, contractors, third parties. Okay, so confirming processing. We have another shall change to may here, similar to the sales and shares. Businesses may provide a means by which a consumer can confirm that their request has been processed. This was changed, like I said, from a requirement to an option. So a business does not have to confirm that they've received that request and are processing it. So a good example here is if a business uses a toggle or a button that limits the use of sensitive PI, they don't then have to confirm that that button or toggle has been turned on by the user. And then just important to note that, we found this little snippet in the comments here, the response to the comments, that businesses must limit the use regardless of when the PI was collected. So if personal information was collected, sensitive personal information was collected prior to January 1, 2023, you're still going to have to limit that use. Although the new obligations under the CPRA are prospective, businesses still have to honor the request regardless. Okay, and so like we have been promising, I am finally going to pass it over to Dave to cover opt-out preference signals.
Yeah, thanks, Shelby. So opt-out preference signals, OOPS, I guess we're big on our acronyms, that's oops, I guess, in privacy world. There's not a good joke. The dad jokes are the best jokes, right? But that's maybe not the best joke. So, but opt-out preference signals. So an overview, again, I've said it once, I said it again. If you look at the comments to the final statement of reasons, right, there's like pages. There's actually one page where they kind of list all the comments down on the side of everyone who said, no, it's not mandatory, it's optional, right? And that argument is done, at least for now. I guess somebody could challenge it in the court if there's an enforcement action or something along those lines. But the agency has said, recognizing the opt-out preference signal is mandatory, right? And that's, I think at least with our clients, we've baked that in for a while now. And this was always the tension that you saw because the Attorney General's office had said global privacy control signal needed to be recognized. And they said that, a year plus ago, right? And we've been pushing out those updates. So this is where we thought they were going to end, right? But there was a lot of people who argued that no, in fact, it's optional, it's not mandatory, but it's mandatory. Anyway, you get the point. And so, even if you post the opt-out links, right, you've got to be honoring these signals, although you can get rid of the links if you do it in a frictionless manner. We'll talk about that in a second. We've been talking a lot about like sensitive PI, right? And so if you look at the statute, it says that the opt-out preference signal will, should effectuate a limit the use of sensitive PI request as well. But I'm going to tell you, the reality is everybody recognizes like we don't know how to do it yet, right? It hasn't been invented. And so because of that, the agency just said, listen, it's going to be limited to the opt-out of selling and sharing at this point in time, and we'll leave the sensitive PI till later, okay? Again, this third box confirmation a business may display whether it's processed as signal. Frankly, we're seeing this pretty prevalent with cookie management tools, right? I mean, it's for OneTrust. I know we were just looking at that for a client. It says opt-out preference signal honored at the top of the cookie management tool when you show up. If you have enabled, like if you're using, say, Privacy Badger or Blur or Opt Me Out or something like that as a way to test, the opt-out preference signal honoring, So we're seeing, privacy tech catch up, and even though it says May now, that they're actually showing that they've recognized it. Okay, so processing the signal. Listen, guys, it's changed, and it's kind of dense, and so we're going to try to tease it out a little bit. And it's across a few different issues. It's across like synonymous profiles. It's across loyalty programs, and it's across what happens with logging into an account. So just bear with me for a minute as I try to get this across the finish line here. So first thing is, okay, so somebody shows up on your website showing the signal, right? They've got a browser extension, browser, whatever, right? So the signal is hitting your website, right? You've got to treat that, and you know this already, as an opt-out of the sale and the share, right? And you got to associate that with any consumer profile associated with that browser or device, including synonymous profiles. So this is something that came up a lot. I mean, Sultani was talking a lot about it in the rulemaking process about this concept of synonymous profiles, but you got to be applying it, right? And then if the consumer is known, then you've got to treat it as a valid opt-out to the consumer. We're going to get into that a little bit with accounts as well. You do have the ability, if you want, you can provide the option for the consumer to provide additional information, so the request can apply to the offline sale and sharing. But if the consumer does not respond, then you've got to process it at the browser, device, and profile level. And again, right, so like we're talking about effectuating the full request here, right, online, offline. And keep that in mind, right? It's not just cookies we're talking about at the end. Okay, so the conflict with the financial incentives thing. So the fact pattern here, right, is say you have a financial incentive, and many people do have financial incentives. We're all like to be part of loyalty programs. I remember one, lawmaker standing up in another state, and they said everyone loves their loyalty programs, right? It seems like everybody always refers to Starbucks as their loyalty program, right? So everybody loves their loyalty program, right? But to enter into loyalty programs, I mean, what is the business getting? They're getting your personal information, among other things, but that's a big piece of the puzzle, right? And some of the conditions of entering into a loyalty program may be the fact that they are selling your personal information. So the one I think people would talk about on the floors of legislatures was things like, well, you go to the food store and you've got a loyalty program there, but they've got a gas station connected to it. So you buy a certain amount of, food, then you get a certain amount of money off of your gas, right? That's a good thing, right? It's a good thing, but that's a sale of data, right? Unless it's structured differently, that's a sale of data. And so the concept is, okay, I come to the website and, I'm a loyalty program member and I'm flashing the opt-out preference, GPC. How does that impact the fact that I've already agreed to the sale of my data for purposes of the financial incentive program? And that is, in fact, like necessary piece of the financial incentive program. So this all got teased out in the rulemaking process. We listen to the hours of rulemaking so that you guys don't have to, right? And just give you a slide. And here it says, the second one, the path forward one is the business can notify the consumer that processing the signal is going to withdraw them from the program and ask them to affirm. Right, you're not just going to assume, because it's counterintuitive. Just because somebody's showing up saying "Don't track me on the internet," doesn't mean that they want to get out of your loyalty program. Okay, if they say yes, I in fact do want to get out of your loyalty program, it's easy enough. Get out of the loyalty program, right? If the consumer does nothing, right, then the business can ignore the signal with respect to the financial incentive participation, as long as the consumer is known to the business, right? If you don't ask though, then you've got to process this signal as a valid request to opt out for that browser or device and any consumer profile associated with the business. Okay, so point being, you're running a financial incentive program, you're onboarding, opt out preference signals, GPC, all that type of stuff. Think about how this interplays with these and walk through these examples. In the rules themselves, they have a number of examples of people and how they come to the companies. Okay. Signals and accounts. This is the other sort of one that we had to kind of flesh through with the rulemaking process. So the fact pattern here is consumer visits the site with the opt-out preference signal, right? GPC. They're not logged into their account. So say you have an account and email, password, that type of stuff, log into the account, right? The business, so they're not logged in, they just have the preference signal. You process that for the browser, right? At the browser level. But say they visit the site and then they log in, right? So now you've got to process that signal for the device, browser, account, and any online and offline sales and shares. Basically, you have to associate that preference to the account level, okay? And then you say, okay, well, what happens if that signal actually conflicts with, consumers' existing privacy settings? Well, then you can ask them to consent to the sale and the sharing. That brings back all the stuff TK was talking about with consent, right? Okay. Now, the third bullet point is where it gets really hairy, right? Which is, so somebody has come to your site, with the signal, they've logged in, you have associated that with their account level, right? But what happens if they show up on another device that doesn't have the opt-out preference signal, right? So, and then at that point in time, they log into the account, right? So I'm using my phone, opt-out preference signal, I'm using my wife's, or I said desktop, probably easier example, does not use the opt-out preference signal, but I log into the account. At that point in time, what they say is that you can't take the fact that the other device is not using the opt-out preference signal, interpret that as a consent to the sale and the share, right? So again, like with the financial incentive stuff, like lots of sort of stuff to kind of navigate through on these issues. And that's all new stuff that we've seen in the revised regulations since we talked with you guys last a few months ago. Okay, friction. We talked a lot about friction. You can comb through the statute. You're not going to find the concept of friction, but it's in the regulations. It's important. So again, have to recognize the signal, but if you recognize it in a frictionless manner, you don't have to provide the links, right? Non-friction, links. Frictionless, no links, right? So what is an example here? Then Business R only sells it for cross-contextual video advertising. It may use the exception and not post the seller share link because the consumer using a signal would fully effectuate their right to opt out of the sale and share. Again, frictionless, right? But that concept that it's done frictionless. So, okay. And then, what does frictionless mean? You can't charge a fee. You can't change the experience, and you can't, mess around with people with this user experience. Remember, I kept on talking about user experience at the beginning, like a lot of this stuff, right? You can't display notifications, pop-ups in response to the opt-out preference signal. There are additional requirements here. Privacy policy disclosures describe the right to opt out, and so on and so forth. 3 other points there. I think, the last bullet point on the full opt out here, the last box here is kind of, again, I said this before, but it has to fully effectuate, right? This frictionless, it has to fully effectuate. If it's a frictionless, you're going to take the links off. And that means if you're doing offline sales, right, you got to think that through, right, about how that's going to work. And they talk a lot about in the regs too about like, having a methodology, this 2-tier kind of methodology for online sales and offline sales to make sure that you can effectuate an entire opt out of sales, not just like tracking technologies. So again, a lot to unpack here with respect to the opt-out preference signals. And Colorado, if you're subject to Colorado as well, that's going to be something as well to navigate through, because there it's universal opt-out mechanisms, different name, but same sort of outcome, right? But no concept of friction either. So a lot to unpack if you are a 5-stater here. Okay, so let me turn it over to TK to hit our last topic with 2 minutes left to go.
Yeah, thanks, Dave. So service providers, contractors, and third parties. As you may know, the CPRA created a new category of persons, contractors. Section 750 to 53, the final regs clarify who's considered a service provider, contractor, or third party, and provide certain requirements for those specific parties. So the CPRA requires that all transfers of PI from a business to a service provider, contractor, or third party require a contract. And keep in mind, failure to have a contract in place with your service provider thus means that the transfer is a sale, and that you'll need to meet the additional requirements for sales under the statute. Section 7051 also provides a due diligence requirement, which the agency further clarified, saying that this section it's necessary to ensure that these contractual provisions have actual meaning, and businesses don't shirk their duties to ensure that disclosed PI is used in a lawful manner. A similar requirement is also provided for third parties. And as kind of a side note, if you can remember the example slide that I mentioned earlier, where the regs replaced analytics business with a third-party ad network. So the agency's response to comments we highlighted here suggests the issue of whether an analytics provider is a service provider or a third party remains unclear. So on that helpful note, now back to Dave to sign us off.
Yeah, thanks, CK. And we've hit our time, but I always have the last slide. I always say this is the shameless plug piece of the webinar. If you've gotten this far, maybe you'd like to hear some more, subscribe to our blog. I know thousands of you are, right? So I'm not suggesting that all of you aren't already. But again, you can use your camera with the QR code right there to get to the blog. Listen, I'd like to thank you. I think probably what you're going to see from us pretty soon is an invitation to a Colorado Privacy Act rules webinar for those of you who are subject to that. So stay tuned for that. No rest for the weary out here in Privacy World. But we really appreciate you guys showing up, appreciate your patience and sticking with us through this one. And we'll be talking to you soon.